Jegarajah. I'm one of the leading asylum lawyers in Sri Lanka. In the UK, not in Sri Lanka. I'd be shy if I went to Sri Lanka. I represent a lot of former LTTE combatants. I've also initiated a lot of private prosecutions against the Sri Lankan army. So what I'm going to do at the moment, I know I'm speaking fast, there's a lot of material. What I say is going to be condensed into a document that will be available by email if anybody wants it. I'm going to talk about two issues, which is the fast-moving developments in the European courts, the European Commission in terms of the prescription of the LTTE. I'm also going to deal with exclusion of the LTTE in the context of asylum and refugee determination. So the very complicated situation is that each European country has different domestic interpretations of the Refugee Convention when it comes to the exclusion of those who were involved with the LTTE, either as combatants or in any other intelligence capacity. So you can have a situation where somebody wins in their asylum case and may not be excluded under Article 1F of the Geneva Convention, but may later, when they apply for settlement or citizenship, be refused a settlement application or a citizenship application on the grounds that their involvement with the LTTE causes the British Home Office to doubt their good character. So I think it's the case for all European countries that when it comes to citizenship, there is a very wide prerogative when it comes to dismissing citizenship applications. And so we have had a lot of those refusals in the UK. And of course the problem with that is that there were many people who were living in LTTE territory, it basically amounts to a discriminatory refusal of citizenship. But when it comes to the interpretation of the exclusion clauses in asylum, it's very different to the way that the EU and the European, the ECJ approaches whether or not the prescription of the LTT is valid in EU law. So that's a little bit of a complicated issue. So you have asylum determination basically taking on one course, and you have the ECJ taking a different view, because of course the ECJ are looking at their own directive when it comes to the validity of prescribed organisations, and it's not just the LTT, it's also Hamas and a whole range of other organisations where very similar arguments come forward. But because the Tamil diaspora, in terms of its international coherence, is quite well prepared, they've been able to forward very, very detailed legal submissions. So in terms of asylum in the UK, as far as the UK Supreme Court is concerned, the legal principles are that when you interpret whether or not someone is excluded under the Asylum Convention, you have to look at the autonomous meaning of Article 1F and not the domestic interpretation. In other words, when it comes to refugee determination, you don't look at the word terrorism, you don't look at anti-terrorist legislation, either internationally in Europe or in the UK. In fact, what you look at is you go to the ICC statute, you go to the Rome statute. That is the main international document for working out whether or not you are to be excluded under the Refugee Convention. But of course that contrasts with any, when we look at the directive at the European Court of Justice, because the ECJ doesn't look at the directive and it doesn't look at principles that are relevant to asylum law. So there's a massive disconnection in terms of the way the two courts approach these questions. The leading case in the UK is JS and the Secretary of State, and that was a case where a bodyguard of Patu Aman, who was the commander of the intelligence unit, was excluded under the Geneva Convention. And the view that the Supreme Court took was that you cannot describe the LTT as an organisation that's predominantly terrorist in character. The reason being that it was predominantly a conventional organisation that fought against the army. And the Supreme Court also took the view, which was quite surprising, that even the intelligence wing of the LTT was not terrorist in character. So the view that the UK domestic courts take of the LTT, which is very much based on your individual activity and whether or not you should be excluded, is very different to the view that the ECJ takes. Now I just want to look at the Swiss case. So the Swiss case is big news at the moment because So this is a case where one of the organisations that the government of Sri Lanka calls an LTTE front, which is the TCC, or the WTCC, the Tamil Coordinating Committee, there was basically a raid in Switzerland and a whole load of people were arrested. And it was all to do with fundraising and whether or not these funds were raised for the LTT. And on the 14th of June on the 22nd of February 2019, the Swiss court took the view that this organisation, its structure, its staff, the role of its executives and their activities were generally known within the Tamil community and outside. And they made a distinction between this organisation and the LTTE, which was less transparent. They said, in reality, it should be noted that the LTT and the WTCC were separate and sovereign entities without a common core with different activities. So this was quite a big, this was a very important legal result, because the government of Sri Lanka was basically feeding the Swiss government with a lot of information, because the government of Sri Lanka wants to close down all Tamil diaspora political organisations, because it is those organisations that are still pushing for the prosecution of Sri Lankan